Hey everybody, John Skiba here, and in this video we're going to tackle some really advanced level consumer warrior tactics when it comes to fighting junk debt buyers in your debt collection lawsuit. We are going to tackle the business records exception to hearsay, why it's so vital to winning your case, and I'm going to try to break it down in a really easy to understand way. But if this is your first time here to my YouTube channel, go ahead and click subscribe, check on that little bell, that way you'll be notified each and every week when I provide you with valuable information to help you deal with your serious debt problem. All right, let's talk about hearsay. And this is not going to be introductory level type stuff when dealing with junk debt buyer lawsuits and defending against them. I'm going to try and explain to you the power of objecting to evidence that the debt buyer provides based upon the fact that it's hearsay, and some of the anticipated responses that you're going to get from the attorneys for the junk debt buyer, and how you can only break it down and still prevail on this. So this is a very powerful tool. You can raise the objection to hearsay on evidence they submit, whether it's in summary judgment or whether it's in trial. And basically what you're saying is, look, Judge, this evidence shouldn't be admitted and shouldn't be considered when determining whether you're liable on the debt, whether they own the debt, determining the amounts owed. And I'll show you some practical applications of this as we kind of get into it. But let's talk about what hearsay is. Now, let me give you the actual legal definition of hearsay based upon the Arizona rules of evidence. And I should say this, most evidentiary rules are the same, whether from state to state, federal. There's some little differences, but usually the language is very similar. So in Arizona, hearsay is defined as a statement that the declarant does not make while testifying at the current trial or hearing, and that the party offers in evidence to prove the truth of the matter asserted in the statement. Okay, so that's kind of a mouthful there as far as what hearsay is. Essentially what it is, it's an out-of-court statement that somebody is bringing into court to prove the truth of what it is they're trying to assert. To boil it down even further, it's like being in court and saying, well, this is what so-and-so told me. You can't do that. They need to bring so-and-so into court, have them testify, not you testify on their behalf. And so you see this in court when someone gets up and testifies, and usually what happens is the lawyer will say, well, what did so-and-so tell you about this? And then you'll see this objection raised to hearsay because instead of having the witness tell what somebody else told them, they should bring in the actual person who made the statement and have them make it. This applies to not only statements, like oral statements, like a witness testifying, it applies to written documentation as well. So if there's a document that's an out-of-court statement, then it's hearsay. And hearsay is typically excluded. So if someone is asking, what's this out-of-court statement you want to bring in? If you object to it, the court should sustain it as hearsay. Now, there are some exceptions to the hearsay rule. There's actually quite a few exceptions to the hearsay rule that allow the courts to be able to process evidence that they've deemed trustworthy in a more efficient and reliable way. One of the main ways that the debt buyers can get over a hearsay objection, because usually things like monthly statements, even their purchase contracts, all those documents, technically they're out-of-court statements, and so they're hearsay. And so the way that they get those in is through what's called the business records exception. Let me share with you the Arizona version of the business records exception to the hearsay rule and how it's applied in junk debt buyer cases specifically. Now, this rule is found in Arizona. It's found in Arizona Rule of Evidence 803-6. That's section 803, subsection 6. And then there are 5 different subcategories of it, A through E, and we're going to go through each of those as far as what they mean. Now, and it should be around 803-6. It is in the federal rules and most other states, the rules of evidence. You can look for the business records exception to hearsay, but it should be around Rule 803-6. So let's go through it step by step. So Rule 803-6 says that a record of an act, event, condition, opinion, or a diagnosis is admissible if, subsection A, the record was made at or near the time by or from information transmitted by someone with knowledge. So the first requirement that a junk debt buyer has to be able to testify to when they're trying to get a document admitted, they have to be able to testify whether that document was made at or near the time that the information is contained within the document as far as when it was created. So a good example of this is like a monthly statement. The witness would need to be able to testify that the document that's dated May 15th of 2016 or whatever the date is, that document was made at or near that underlying time. That's the first requirement. Second requirement under subsection B is that the record was kept in the course of a regularly conducted activity of a business, organization, occupation, or calling, whether or not for profit. So the other requirement is essentially that the witness has to be able to testify where the document was stored or how it was stored. How did they keep these documents so that we have some trustworthiness that they weren't tampered with or the problems were caused with them. Subsection C requires that there must be some kind of testimony or information attesting to that making the record was a regular practice of that activity. So, for example, let's talk about the monthly statement again. So if you have a credit card with American Express, clearly it's within their normal course of business and course of practice to create monthly statements and send them out. However, if they were creating some other type of document, let's say that they were creating like an affidavit or that they were creating some kind of work order or something that just wasn't the normal thing that a credit card company does, you could argue that that is not part of the ordinary course of business that they created that particular document. We especially see this on documents like affidavits that are prepared just for court purposes, that the only reason they're preparing is because they sued you. That is normally not prepared in the ordinary course of their business. Subsection D says that all these conditions, meaning A, B, and C, those prior subsections, all these conditions are shown by the testimony of a custodian or another qualified witness or by a certification that complies with Rule 902.11, yada, yada, yada. So that one is saying, look, subsections A, B, and C, they have to be testified by a custodian of records or a witness who's qualified, who's shown that they have this information readily available to them and they know how all these things happen. Because so subsection A, again, they have to be able to testify that the document was made at or near the time of the information that's contained within there. B, how they have to be able to testify how the document was kept, as far as how it was stored, how they, what the whole process was. And the third one is they have to be able to testify that the record was made as part of the regular course of business for that company. Now, subsection D is super important because in a junk debt buyer case, the witness who testifies, often they are an employee of the junk debt buyer. They're not an employee of Chase or Bank of America or Wells Fargo or Citi or whoever it is. And so the reason why you can often object to documents being hearsay is because the witness is not qualified. Subsection D, they have to be able to testify from a base, from a knowledge base as far as knowing how Citibank, how did they keep and maintain their documents? Do they know if this is what the storage process was? Do they know if the document or the monthly statements were made at or near the time of the information that's transmitted in there? And if you ask them questions about what their qualifications are, almost routinely they will state that they don't know those specific procedures of the underlying creditor. When I cross-examine a witness, I will often I'll start out by saying, excuse me, I will start out by saying, you work for Midland Credit Management, correct? Correct. I'll ask them, have you ever worked for Citibank? No. Have you ever been trained by Citibank as far as how they keep and maintain their documents? No, I haven't. And then I'll go through and pick apart these things. How could they possibly know when the record was made? They haven't even been trained by that company. They've never worked for that company. And you get all of those things out on the record, and then that can help you to establish that they don't have what's called the foundation to be able to testify and overcome the hearsay nature of this. Subsection E is important too. It says that the opponent does not show that the source of information or method or circumstances of the preparation indicate a lack of trustworthiness. This is also a very important part of the exception to the hearsay rule, because if there's anything in those documents that should, give the court pause, why does it look that way? Often we see this with like bills of sale, assignment documents, where you'll have the bill of sale and then they'll have a document like it'll say that all the accounts transferred are listed in Exhibit A or Schedule A. But then you look and either there is no Schedule A, the Schedule A is completely redacted. Or what I see a lot is that the schedule is actually like in a different font. Maybe the bill of sale looks like it's a document from 6 years ago, and it looks like the schedule was printed off 2 days ago. That kind of thing, where clearly there's some inconsistency that should give the court some concern about the trustworthiness of the documentation. So that's something to look at as well, is if there's just something that's a little off on the document, then you can raise this issue. So when you are dealing with a debt buyer case and they try to introduce documents from the original creditor, you can object to that document coming in based upon hearsay. And then you can need to be prepared to discuss why the exception to the hearsay rule under 8036 is not applicable. And it's the general rule is that it's because under subsection D, they don't have a qualified witness who can testify as to A, B, and C, or there's something just inherently wrong with the document under subsection E. So I know that's a lot, but it's one of these things. If you just look at the rule, look at Rule 8036, check out Rule 802, that's the rule on hearsay. 801 also gives you the definition of hearsay. As you look at that, all you got to think is that, look, the court only wants to have evidence that's reliable. They want to have information that they can trust that's coming in here. And they only want documents where there is someone who understands or has the proper knowledge to be able to testify about them. Only those types of things should come in and be truly evidence. And if the witness doesn't know how the original creditor created the document, saved the document, and stored the document, if they don't know that that's part of their normal course of business to create those documents, that document should not come in. And so this takes a little bit of preparation. Unless you've done it a million times, it's not something you want to just shoot from the hip. You want to take a look at the documents, take a look at the rule against hearsay in Rule 801 and 802, and then look at the exception under the business records exception under 8036. Let me give you one little asterisk, particularly if you're in the state of Arizona, a couple other states, and some of the federal jurisdictions. Some of those states have what's called the rule of incorporation, where they're saying if the documents have been incorporated into the documents of the junk debt buyer can then testify about them as if they were their own documents. I don't understand how this is just a pro-creditor evolution in the law, because it doesn't make sense. It essentially just obliterates Rule 8036 for the courts to say that. However, one way around it is is that in order for that to be true, the debt buyer has to be able to testify when those documents were actually incorporated into their own documents. What you'll often find is that when they buy these accounts, very few documents actually change hands. Nothing's really incorporated into the junk debt buyer's records until a lawsuit's filed, and sometimes not even until those documents are requested by you as the defendant or the court's requiring it. So often you can show that they've never been really incorporated into their records, and so they shouldn't be able to testify. So I hope that's probably clear as mud. But it's a very important part of winning junk debt buyer cases, particularly if they filed a summary judgment motion or if you're in court. Objecting to the documents as hearsay can take you a long ways. You can get a lot of traction on that, and you can win your cases by getting those documents thrown out. Because if they're thrown out, then they're in a situation where they can't prove the amounts owed. They may not be able to prove ownership, and there just really isn't any evidence there for the court to rule on. So if you have questions on that, go ahead and put them down in the comments. Hope that helped today. Thanks for watching.